All right. So, welcome everyone to our webinar today about keeping generational wealth in the family. And this is such an important topic because not a lot of people are talking about it right now. And as I go along, you're going to understand how important it is because um, just traditional estate planning, there are so many pitfalls that you can go into. It's not created for today's families, and we're going to get into the specifics of this as well. Okay, just before, before we start, I want to tell you that this webinar is for educational purposes only. It does not create an attorney-client relationship because you attended, and it's based on Florida law today, right? Laws change all the time, and this is based on the law as of now. Planning strategies also require individualized advice. So each family is different. Each family has its own family dynamics, and it's so important to base your estate plan on your specific situation. All right, so I want to start by explaining to you this situation that's happening right now. This is not something that's going to happen in 20 or 25 years, but right now there's a great wealth. It's called the Great Wealth Transfer, the largest transfer of wealth in human history. Okay, and I'm going to go into a deep dive what that really means. Over the next 20 to 25 years, there's wealth is shifting from one generation to the other. Okay. So individuals are passing away and parents are passing away, grandparents are passing away, and their wealth is transferring to their children, to their grandchildren. This transfer is happening right now. It's not happening at some time in the future. So we really need to be talking and thinking about this now. Okay. So how much wealth are we talking about? Is it a couple of million, millions, billions of dollars that are being transferred? Well, it's a lot more than that. It's over $80 trillion. Yes, you heard it right. It's over $80 trillion is expected to transfer. And this is only in the United States from one generation to the other. And this is why it's so important to be talking about this topic right now. The majority will pass from baby boomers, and who's going to get the money? Gen X and millennials. So Gen X and millennials are going to be very wealthy individuals, okay, within the next 20 to 25 years. Okay, so what does that include? It includes homes and real estate, rental properties. A lot of people have rental properties right now. Retirement accounts, so 401ks, IRAs, Roth IRAs, business interests. So if you have an LLC or a corporation or some kind of business, that once like I pass away, my business is going to go to someone else, right? Someone's going to inherit my law firm. And I'm very happy because we have got a lot of attorneys in my family. My son is an attorney as well. So business interests, and life insurance. So term life insurance, whole life insurance, investment accounts as well. So if you have stocks and bonds and so forth, as well as tangible personal property. We're talking about jewelry, we're talking about cars, art, anything of value that's touchable is tangible personal property. But so what's wrong with that situation? There's nothing, right? We work really hard so that we can pass our wealth to our children and our grandchildren, right? Well, there is a problem that's going on and which needs to be addressed. Okay. The hard truth is what actually happens to inherited wealth. And this is a really important thing to realize. So approximately 70% of inherited wealth is lost by the first generation. Yes, you heard it right. 70% of the money that our children are going to inherit is going to be gone during their lifetime. And then by the second generation, 90% of the wealth is gone. Okay. So where is the wealth going? It's not just going for the living expenses, it's going to other places. And then we're going to discuss this. Why is the wealth going? So there's no planning and outdated documents. So recently I had a client come in and they were grandparents, they were retired, and their will was at the time they created a will, and their will reflected on who would be guardians for their minor kids. So they haven't updated their will since their children were minors. Okay. And I will tell you that will definitely did not work for them. And it would have been a disaster if one of them had passed away. It was definitely needed upgrading. Poor asset protection. Can you create asset protection inside your estate plan? You definitely can. There are a lot of, you know, guards that you can put in place to protect that money and not have it, lost 70% of it or even 90% of it. Creditor claims. So your children and your grandchildren's creditors can come after their inheritance. Is there a way to actually um, make sure that doesn't happen through your thoughtful estate plan? Yes, there are ways to do that as well. Divorce, when our children inherit, unfortunately, we have no idea what's going to happen to in their lifetime. They can get a divorce and their spouse can take their inheritance away. Lack of financial education. So some people like they inherit all this money and they think they are wonderful in finances. So they open up a brokerage account and they start investing money in stocks and bonds and they lose it all because they have no idea what they're doing. So there's no guidance and no accountability. And we hear these stories a lot that people, they win the lotto. And what happens is that they lose it all. They lose everything in a very short time. And they actually, not just they lose the lotto, their lottery money, they file for bankruptcy. So money can really ruin people's lives. And inheritances can also ruin people's lives. And we're going to talk about this, and I'm going to show you some examples as well. So some of the myths that we have is that a will or a basic trust is enough, and it's going to take care of all my problems. It's going to take care of my family moving forward. A basic estate plan does not take into it does not keep in mind second marriages. It does not keep in mind what happens if my spouse remarries. It does not keep in mind blended families or other problems that come up in a family dynamics. Okay, they ignore all these things. They ignore divorce. They ignore creditors. They ignore frivolous spending as well. So pitfall number one, when someone comes to my office and say, okay, it's outright to my child or my children. I want everything to go to my child. Okay, so let's talk about this scenario. What can happen in that scenario? Child inherits everything outright in their name. Child later dies, right? We're not even going to talk about divorce, but what if my child passes away? What happens to the money that they inherited from me? Their spouse inherits that money under the Florida law. Okay. And then assets leave the bloodline. How do assets leave the bloodline? So let me tell you a story where grandfather, he said that after his passing, he wanted the oldest granddaughter in the family to inherit his home. And everybody loved her. Everyone got along very well. She was married. Her husband was great. Everything was wonderful. And grandfather died. She inherited the home. And then later on, a year after she died, and her husband inherited the house. After her passing, her husband remarried. And now the grandfather's home is owned by people who are not even related to him. And in this situation, the family tried to get the home back. No attorney wanted to take this. They finally found something. They tried. They first told the son-in-law, can you please give us the home back? Because grandfather didn't mean for this to happen. He didn't want it to go to people outside of our family, but he said no. And he had every right to. He inherited the house from his wife who passed away. He had all the legal rights, and the family lost the home. Okay. And this happens in different ways as well. It happens in divorce. I'm also going to tell you about the elective share, the Florida elective share later on in the presentation. We'll talk about that as well. The second thing is that if you're married, you say everything to my spouse outright. It's like, okay, it sounds fine. You're getting along. Everybody loves each other. Everything is fine right now. Once someone passes away, it changes the dynamics of the family. Okay. And it really doesn't matter. I've seen it happen in my family. I've seen it happen in other families. You don't realize once someone is missing from the family, it automatically changes the dynamics. We don't know how it's going to change it for the better or for the worse. Is it going to bring people together? Is it going to people are going to just drift apart? It may do both with some people, with not with others. So definitely this can cause problems. So let's take this scenario: surviving spouse owns everything. If I say everything to my spouse, surviving spouse owns everything outright. Surviving spouse can remarry, and we're seeing a lot of this right now. Individuals who are in their 80s, they're getting remarried. They're having significant others. They're, living, partners. They have partners that they live with them and so forth. And as soon as a spouse passes or shortly after, the surviving spouse, they can change the estate plan. And if they have adult children, they don't have to give them a penny. Okay. They can completely disinherit their children if they want to, and if they're competent. And this happens more often than you think. I had a client who's telling me that her mom came from a lot of wealth. She inherited a lot of wealth from her family, and then her mom passed away. They had a wonderful marriage. Her mom and her dad, they loved each other. Everything was wonderful and amazing. Her dad inherited everything, right? And then shortly after, he announced he's remarrying. And when he remarried, shortly after, he changed the estate plan to give everything that he inherited from his wife to the new spouse and to her children, right? And they were completely disinherited. And there's nothing that she or her siblings could have done to avoid this. It could have been avoided from the get-go when the estate plan was done between her dad and her mom. And again, this happens more often than you think. So let's talk about blended families, blended, beautiful families. Nowadays, I want to say 50% of families are blended families. And the traditional estate planning does not work for them. Okay. And so let's talk about what that means. I have a lot of people that would come into my office and say, you know what? Blended family, we love each other very much. And this was a situation. They were telling me that the wife was telling me that her children actually go on vacation with her husband's children. So they're step siblings, but they love each other very much. They're so close. Okay. And that she knows that if she passes away, her spouse would never disinherit her kids and he's going to do the right thing. I have seen this go wrong in so many ways because, okay, again, we talked about once someone passes, it really changes the family dynamics. Competing loyalties, right? So if you have a blended family, let's say wife passes away, now the husband has his own children. And sometimes we just feel we're more loyal to our own children, even though there are children that we loved for stepchildren and so forth. These stepchildren also, as time goes by, we don't know if they're going to keep the relationship between them and their stepfather and their step brothers and sisters. We have no idea what time will bring and what that relationship is going to look like. So if you have a blended family and you say everything to my spouse, okay, That spouse owns everything. They don't need to give your kids anything, and your children, okay, they have no duty to give stepchildren anything, and your children could be completely disinherited. Can we make provisions in an estate plan to make sure this does not happen? Yes, 100%. There are ways to do this. And, prenups, postnups, um, separate property agreement. There's a whole lot of planning that can be done. I recently did this for a family that can be done in a very thoughtful and heart-centered way so that your children are not disinherited. So other things to consider. Florida elective share. So what is a Florida elective share? It's a Florida law that you cannot disinherit your spouse. If you are legally married, your spouse is owed at least 30% of your estate. 30% of the money belongs to your spouse. It does not matter if you said you created a will and the will said that everything to somebody else. Okay. But there are ways of bypassing this elective share in an estate plan, should you choose to do so. Okay. Again, prenups, postnups. I recently had clients who kept they had a blended family, they kept all their assets separate. And we created this estate plan to allow their separate assets to pass to their children without the elective share coming into play in any way. So there are ways to bypass the law. Okay. The law says certain things, Florida law, but you have a right to change that. We do have leeway in estate planning to change that. The next thing we want to talk about is homestead restrictions. Okay. There are homestead restrictions override estate planning, but there are also creative ways of going, I'm not going to say bypassing it, but creating an estate plan to make sure the homestead goes where you want it to go. So I'll give you an example. I had a situation where it was a second marriage, and the wife had bought this home. And when she got married, her spouse moved in with her, and she added him on the deed. Okay. So they came to me, they were both, but she told me that when she passes, even though he has other children, he's going to give the house to her children. Okay. That's what she said. But can he not give it to her children? Yes, most definitely. He doesn't have to, because now that he's on the deed, they, as husband and wife, they both own the home 100%. So if wife passes, he owns it 100%, and he has a right to give that home to whoever he wants to. But there are ways where we can create right to occupy. There are certain creative ways if you want, if this is your home and you want it to go to your own children, and you still want your spouse to live in the home for his lifetime. You want to make sure that he's got somewhere, to live, and you want to protect him. There are creative ways of doing this so that the home does go where it should go in the estate plan. But a spouse, even if you have a home and it's homesteaded property, please understand there's property that's homesteaded and property that's not homesteaded. So this is only applies to homestead property. Your spouse has a right, even if the home is in your name, your spouse has a right to live in that home for their lifetime as well. Extended family, so right to occupy. Well, I do want to go into this a little bit because I'm finding that a lot of people do want to include this in their estate plan. So I had a client, she married, and she bought a condo. She has a condo in her name. It's not homestead, and her mother lives in the condo. So her mom can't afford to buy a condo. She bought a condo. She has her mom living in there, and she wanted to make sure that if she passed away first, that her mom has the right to occupy the condo, and that her and the trust also pays for the taxes and supports her mom. It's funny because her husband's like, you know what do you think? I'm gonna kick your mom out of the house when you pass. I'm not gonna do that. But she wanted to make sure everything is spelled out in her estate plan. It's really an act of love for your family. It prevents fighting. When you spell out everything, it really is an act of love because you know, everybody knows what your wishes are and they have to abide by your wishes. So the right to occupy is is a specific type of planning. Should you want to, allow, I have another situation where this woman, her parents live with her, and if she passed away, she wanted her parents to continue living with her until they pass away. It's right to occupy is also great because we are finding, I'm also finding that a lot of people, elderly, may not want to get married, but they have life partners who live with them. And unfortunately, I get this call maybe 3 or 4 times a year and it's mostly from women. They will call me and say, I lived with my life partner for 20 years. He wrote on a piece of paper that I can live in the house when he passes, or he wrote on a piece of paper that I can have the house. Now, that's not a legal document, writing on a piece of paper and just signing your name. That will not hold anything in court. Um, and she tells me, oh, his children, I had a wonderful relationship with his kids, and I took care of him when he was sick, and I did all this. And then the week after their dad dies, I'm getting evicted from the home. This is happening a lot. And all of a sudden, they won't talk to me. They're telling me to go get an attorney. These kids, I took care of their dad when he was sick. They told me how much they loved me. I treated them like my own kids, and now they're evicting me. But there is a way in estate planning to allow your life partner to live in the home for their lifetime. And there's creative ways of doing that as well. Okay, so I want to talk to you about traditional estate planning, which is not what I do, okay, with most of my clients. Most of my clients that come to me do not want the traditional. If that's what you want, we can do it. But what I love doing more is life and legacy planning, which is heart-centered planning. So I want to explain a little bit what's the difference between both. Traditional estate planning focuses on the documents. Okay. They're cookie cutter documents. They apply to everybody, focuses on just drafting documents that may or may not work for your family dynamics because each family has different dynamics. Okay. And I get this a lot. Some people, they come to me, is like they talk to their friend, they think their friend's plan is going to work for them. It's like, I want to trust. And when I ask why, they tell me, because my friend told me it's a good idea. I saw it on the internet. And that does not work. It like when whatever you see sometimes or whatever your friend tells you that they did is working for their family and not yours. So traditional estate planning, you go to an attorney, you create your everything to my spouse, everything to my children. We call it a day. It's a very basic estate plan. The second thing is the relationship typically ends at the signing. They give you your documents, goodbye. You don't hear from the attorney for the rest of your life. If you need something, you're the one that has to reach out to them. Assets often pass through probate court because assets are not titled correctly. You're not given information on how to title your assets in the right way. There's an increased risk of assets being inherited by unintended individuals, people who are not even related to you, and it fails to account for blended family, remarriage, or beneficiaries' life changes as well. Okay. So what is heart-centered estate planning? Documents are designed around your family's dynamics, your family's values, and your family's needs. It's not a one-size-fits-all. Okay. I also include a 3-year complimentary review meeting. So on that anniversary, after 3 years, I will reach out to you or my assistant will. And they will tell you it's time to have your 3-year meeting, and I don't charge for that. Let's see if you are in the same situation as 3 years ago. Is your plan still working for you, or we need to upgrade your plan? I also create a comprehensive asset inventory to ensure that your assets are not lost. This is so important. I had a couple come in, and her husband, like, he had 9 bank accounts in 9 different banks, and she had no idea. As we were talking, she's like, if you would have died yesterday, I wouldn't have known to go to these institutions and tell them that you died, and that's that money to go to the family. And if that doesn't happen, guess who gets the money after a while? If your family doesn't know that you've got money in an institution and the bank has no way of reaching out to the family, it's going to go to the state. The Florida state is going to get your assets. Support for property retitlement. Okay, so I would support you to either you would hire me to retitle your assets in the right way, or I would give you instructions to allow you to retitle your assets in the right way. And that's so important, because if assets are not retitled or titled in the correct way, they will go through probate. So this is intentional heart-centered planning that helps to keep your assets within your family. All right, so why am I having this conversation? Okay, I've seen firsthand how well-intended plans fail families. I've seen it in my own family. I've seen it in my clients, and the sad stories that I hear from my clients. Some of them actually come to me because of the situations, because of the horror that they've seen happening in their family. My role, I am a personal family lawyer, is to ensure that your family gets clarity. I'm here to support your family. I'm not here, I'm not just an estate planning attorney. Families come to me whenever they need help. If I can't help them, I will find them an attorney or someone else who can. All right, so what's the first step? First step is not just let's do a consultation. It's a life and legacy planning session. So what is a life and legacy planning session? It's a it's a meeting with me, okay? And I allocate 2 hours of my time for this meeting. Not everybody needs the 2 hours, but if you need it, it's there for you, because I don't like to rush this meeting. We're talking about a lot of emotional things, and we're getting into a lot of things. So some people, they only take an hour. Other people, they take the full 2 hours, and I want to allow that if needed. During this meeting, you are going to get clarity on what would happen if you passed away yesterday. What would happen if you became incapacitated yesterday? So you can be very clear what would happen to your assets, who would get what, according to the plan that you have right now. If you don't have an estate plan, well, we'll talk about what would happen in this situation. And then once you are educated on what would happen, you make decisions from a point of knowledge. You're not just making, oh, give everything to my spouse, give everything to my kids, and let's call it a day. You're understanding what the law says, and you're making decisions from a point of power. Okay. And it's a lifetime relationship again. And during this meeting, I will explain to you, I have 3 levels of planning. Everything is flat fee. There's no surprises, and you get to make decisions for your family from a point of love, from a point of care, in case you become incapacitated or pass away. So I do want to give you 2 gifts for attending today, because I really want to incentivize you to do this. Okay. And the 2 gifts are the following: this 2-hour meeting, because you came here, and I will tell you that right now more than 90% of people out there, because especially this topic, nobody really talks about it. And you're going to be coming to my meeting with a lot of knowledge. I want to give you this 2-hour meeting with me at no charge. I do charge $750 for it, but this is your gift for coming today, and we're at the end of the year, and to attend with me. I also want to give you another gift. um, which is $250 off of your estate plan if you book this by Monday. Okay, you need to, I'm going to put my booking link in the chat. You can click on it and book this meeting. There's different times, and this is a virtual meeting. If you want an in-person meeting and you prefer it to be in person, still book the meeting, the virtual meeting, but let me know that I want this to be in person. I want to come to your office. Um, and so this is also the QR code. You can scan that. It will also get you into my my calendar link to book an appointment with me. So now I want to go into Q&A. I'm going to stop sharing my screen and let's go into Q&A. Well, before I go into your questions, I had two individuals send me questions, and I appreciate that so much that they want me to address. The first one is that some individuals they have properties in Florida, but they live in other states, and how could they protect their Florida property? So there's a couple of ways to do that. Number one, to avoid probate. Number one, you need to do an estate plan in your specific state. And once you create a trust, you can title your assets, the Florida assets, your property, in the name of your trust. And that needs to be done by a Florida attorney. So I have clients that have properties in different states because if I'm not licensed in those states, I cannot retitle their assets in the name of their Florida trust. So what I do is I reach out to an attorney in the other state to have them do that. I'd be happy to do this for you. So that's one way of doing it, creating your estate plan, creating a trust. In the state you live in and that you reside in, where you pay taxes in. And then once you do that, I can reach out to me and we would retitle your property in the trust. One thing I will tell you, if it's a rental property, I don't like to do that. Rental property should be in an LLC. Okay, because it's a type of protection, because if it's in your name and someone slips and falls and you're sued, you're sued in your name. All your assets are exposed. But if it's in an LLC or a land trust or something that contains the home, it does protect your other assets from lawsuits. Another question that came to me is someone that doesn't live, my office is in South Florida. I will tell you that 30% of my clients don't live in South Florida, and I do estate planning completely remote. We do everything on Zoom, and I prepare your documents and put them in the binder. I send them priority mail. They arrive to your home. The binder is completely prepared. Everything is tapped to where you sign, where the notary signs, where the witnesses sign. And I conduct the signing meeting on Zoom. So I send the notary and the witnesses to your home or to your office, wherever you'd like the signing meeting to be. And I'm on Zoom and I conduct it's as if you're in my office. And I've done this so many times. And again, I will tell you, because when I do webinars, a lot of people attending, they're not in South Florida. Well, not a lot, but many people that don't live near my office, they cannot come to my office. And we do it completely virtual, and it works. I have a great process for that. Let's see. I don't see any other questions. If you have questions, please put them in the Q&A section, and I'd be happy to answer your questions. Also, Christine, my client services director, she called some of you just to ask you if you had questions before the webinar. I think some of you, and she left messages for you. She will call you again probably on Friday to see if you have any further questions or if she can assist you in any way. How often do you need to revisit your trust for any changes to be made? Okay. Well, if you create, if you create an estate plan, right? And the next day something major happens in your life, like for example you name certain trustees and you have a falling out with that trustee, you need to change your estate plan immediately. Okay, or you found out this trustee that you named to be your successor, if something happens to you, someone else takes over, has stolen something and now you don't trust them. You come back the next day and you change your estate plan to remove that person, right? So number one, life changes, life situations can happen, and you need to change your estate plan. So at least every 3 years, and that's why I have this complimentary meeting where we sit down and discuss all the, any issues with your children. Or is there will they are in the process of getting a divorce, or do you think there's a divorce that might happen in the future? Do we need to change it, do an asset protection trust for them now, instead of giving them outright? Do you want to protect the money now for the grandkids? Do you have more grandkids? What's going on? So it really depends on if there's a major life change in your life. In your life, you need to update your estate plan, or yeah, if there's any changes. Um, I would, I tell my clients every year, like, just take some time and read it over. I also create like a summary of my clients' estate plan so they don't have to go through their full trust, because I know it could be a bit complicated. They can look at their summary and see who they gave what to. Because a lot of people, like, we don't remember what we ate for breakfast yesterday. Are we going to really remember everything in our estate plan? Sometimes we can't. Um, so that summary also is very helpful. All right. Thank you so much, everyone. Have a happy new year and have a wonderful, blessed rest of your day. Take care. Bye bye.